Good morning, everybody. This is Colleen Cox, and Domestic Abuse Wisconsin Education Coordinator. Thanks for joining us today for this webinar about housing programs. This webinar is the fourth in a series called Get What You Need, about public benefits that might be available to victims of domestic abuse. Previous topics in this series addressed tax protections, landlord-tenant law, and Social Security disability insurance and supplemental security income. You can find captioned recordings of these webinars on our website. And just to let you know about upcoming webinars in this series, we have the Affordable Care Act and Medicaid, which will be on November 8th, W-2 and emergency assistance, which will be on December 2nd, and in 2017, taxpayer advocate.
Well, thank you so much, Colleen. This is Tony Gibbard of End Domestic Abuse Wisconsin. Thanks, Colleen, for handling all of the logistics for us, and thanks to my colleague, Megan Sprecher, for co-presenting today with me. As Colleen said, this is part of the Get What You Need series that we've been holding throughout the year here at End Domestic Abuse Wisconsin to better familiarize domestic violence advocates and others with some of the social safety net programs that can help meet some of the basic needs of survivors of domestic violence. So I'll quickly just go over what we're going to talk about today as part of the housing webinar. We're going to cover rural housing programs, low-income housing tax credits, rapid rehousing and transitional housing programs, public housing programs, and the Section 8 voucher program. And then we'll conclude with talking about some of the housing protections for survivors of domestic violence, sexual assault, dating violence, and stalking that are included in the Violence Against Women Act and that were recently expanded and updated as part of the 2013 reauthorization of VAWA. So we'll be talking at a pretty high level and covering a lot of different programs. It goes without saying that if you have any questions, please ask those during the webinar, or both Megan and I will be are available, and we'll have our contact information at the end of the webinar so that you can reach out with any specific questions you have. So with that, I'll turn it over to Megan.
Good morning, everybody, and thank you for joining us. Before we get started talking about the programs, I did want to mention that HUD, Housing and Urban Development, just recently released a new app. So if you have a smartphone, there is a free app that you can download, and it is interesting because if you type in a location or if you enable location services, it shows you where the closest public housing authorities, multifamily properties, low-income housing tax credit properties, and then USDA rural housing properties are. So the screenshot that you see is actually of my phone, and the little blue dot there is where the End Domestic Abuse Wisconsin office is, and it shows the closest housing programs to our office. And then if you click on one of those little circles, the purple, orange, yellow, or green circles, it will pop up information about that specific property. It will list what types of property, what types of housing they have, what types of units they have. It will list the manager's information, name, contact information, and then information about applications too. So that's a kind of a useful tool because with a lot of these programs you have to go to different websites to find properties under each category. Okay, so we're going to start with a little bit of information about rural housing programs. I'm not going to go into too much detail, but I definitely wanted to mention these and that they are available. So these are run by the USDA Rural Development Wisconsin State Office. And on this slide you have information, contact information, phone, fax, emails. Their website has a document called the USDA Rural Development Wisconsin Program Guide that gets into more details about each of the different programs that the office runs. On the next couple of slides, we'll talk a little bit about some of the more relevant programs to your clients, but there are additional programs. So if this is something that you think would be beneficial to your clients, I encourage you to go to the website and check out that program guide. I also wanted to let you know that coming up for those live participants or participants who are watching this shortly after it was originally aired, there is a webinar coming up on October 25th, 2016, both at 9 a.m. our time and 3 p.m. our time, and it's talking about limited English proficiency guidance for USDA rural development programs. So if that's something that's of interest to you, please email me. My email address is at the end of this PowerPoint slide, and I can send you the information to sign up. So one of the programs that they run is called a Guaranteed Single-Family Housing Loan, and those are loans, so you do have to pay it back, but that's for people who are homeowners and they want to refinance or they're wanting to purchase a new home. It is targeting first-time home buyers, but it is not limited to first-time home buyers. So you do have to show that you have the ability to repay the loan, that you're going to live in the residence, and that you are a U.S. citizen, or you have your permanent resident card or are an indefinite parole or a few other requirements. Your income cannot exceed 115% of the county median income. And I think what's important to note about that is that they don't use the federal poverty guidelines. A lot of programs do use the federal poverty guidelines, but this is specific to your county. So if your county has a lower median income than what it would be on the federal poverty guidelines, that could be an advantage to your clients. The next program I wanted to address is the direct single-family housing loans. So these are loans that you can use to purchase, repair, or improve a home. So not just purchasing, not just refinancing, but if you need to do home repairs, if you want to make an improvement upon your home, this loan program could benefit you. The income guidelines are lower than for what we previously talked about. It's 80% of the county median income. The next program is repair loans and grants. So this is specifically for low income, very low income people, 50% or less of the county median income who are looking to repair their home. It also is very beneficial for folks who are at least 62 years old and are unable to repay a loan, because they would actually be eligible to receive a grant that would not have to be paid back. This is limited to rural residents, so you have to live in a town with a population of up to 10,000, and then there are a few communities with populations between 10 and 20,000 that would also be eligible. Okay, so the low-income housing tax credit is something that is available in both rural and urban areas in the state. So in Wisconsin, the Wisconsin Housing and Economic Development Authority allocates and administers LIHTCs in Wisconsin. And basically what it is, it's federal tax credits that are used to offset income tax liability. So if the owner of a housing development receives these tax credits, they're able to reduce the amount that they charge for rent. So in order to qualify for this LIHTC tax offset, developments must show that they're going to remain affordable for at least 30 years, and that they are going to show that 20% of the units are reserved for households at below 50% of the area median income, or 40% of the units will be reserved for people at or below 60% of the area median income. One thing that's important to note about LIHTC properties is that unlike with public housing or with voucher housing, no grievance procedure is required. So if you have clients that are living in LIHTC properties in your area, it's a good idea to get to know the owners and the managers, because they're not required to have the same grievance procedure that other housing programs are. And so you as advocates would have a role in getting to know the owners and managers and talking to them about what your clients are going through, what their situation is, and how best they can be served. Wisconsin has a qualified allocation plan that talks about the policies for the LIHTCs, and that's definitely an area of advocacy. So you can look at the allocation plan. I included the link, and it is revised periodically, and that is definitely a time when you as advocates can have a voice in telling them what policies are beneficial for survivors and what policies need to be changed. Income is recertified annually, and then I included a link at the bottom where you can find LIHTC properties in your community. And when I looked and I just selected all the counties in Wisconsin, there are several hundred properties. So there are a lot. And as I said before, they're in urban areas and they're in rural areas, so throughout the state.
All right, this is Tony again, and I'll be talking to you about rapid rehousing and transitional housing programs. These are HUD-funded programs that are meant to address homelessness in communities across the country. It's worth mentioning that there's another similar program that we won't be discussing specifically, permanent supportive housing. However, as part of the coordinated entry process that I'll talk about in just a minute, permanent supportive housing is accessed in that same manner, the same way as rapid rehousing. Permanent supportive housing is meant to provide individuals who are homeless with housing and an array of services to meet their needs, and as such it's designed for folks who may have very high barriers to housing and have been chronically homeless. Also, as an initial matter, it's important to point out that the HUD definition of homeless, which is applicable to these programs, is inclusive of individuals and families who are fleeing or attempting to flee domestic violence. So that's an important point for how these programs potentially apply to the folks that you're working with. All right, so homelessness prevention and rapid rehousing programs provide financial assistance and services to prevent individuals and families from becoming homeless and to help those who are experiencing homelessness to help them become quickly rehoused and stabilized. Funds under the program are intended to target individuals and families who would be homeless but for receiving this assistance. And the assistance goes beyond just security deposits and rental payments. It can include utility deposits and payments, moving costs, relocation costs, and some services and case management, including legal services, counseling, and mediation. In comparison to homeless prevention and rapid rehousing programs, domestic violence agencies may be more familiar with transitional housing programs. A number of DV programs have and some still run transitional housing programs specifically for victims of domestic violence. And these are programs that are used to provide kind of interim stability and support for individuals who may be homeless or at risk of becoming homeless. And it typically covers up to 24 months of housing and accompanying supportive services. And so some DV programs who have transitional housing programs, those supportive services are specifically geared to the needs of domestic violence survivors. Transitional housing programs can either be scattered site or congregate housing, meaning they may be, in essence, different apartments that the transitional housing provider owns and leases to participants throughout the community, or they may be all one unit, and so a building that has a number of different units specifically for individuals who are in the transitional housing program. So I mentioned earlier there's a coordinated entry process into rapid rehousing and transitional housing as well as permanent supportive housing programs. All of these housing programs are accessed through continua of care. And many of you are probably familiar with continua of care because many domestic violence agencies are involved and participate in continua of care. For those of you who don't know, these, what are sometimes called COCs, are collaborations between various agencies that receive HUD funding and or are involved in the response to homelessness in that particular community. And in Wisconsin, we have 4 COCs, or 4 main COCs, one for Milwaukee County, Dane County, Racine County, and then the rest of the state is in a large COC that's called the Balance of State. The Balance of State COC is itself divided into 21 separate local COCs, and within that Balance of State grouping of local COCs, all of those local COCs use the same coordinated entry process. And the idea behind coordinated entry is that a person or a family in need of these services can quickly and efficiently be connected to the most appropriate service, no matter which agency they first interact with. This is sometimes called the no wrong door approach. And seeing as most of the individuals on the call are part or serve the area that's covered by the Balance of State, I'll talk about that a little bit more in depth. I believe much is similar for Dane County. Within the Balance of State coordinated entry process, an assessment tool called the VI-SPDAT is used for the prioritization of individuals who need these particular services. And the services are prioritized for individuals who have been homeless the longest and who have some of the most acute or severe service needs. And of course there are income eligibility requirements. Some of the housing programs that may be available through a COC are prioritized for individuals with disabilities, and so as part of this coordinated entry process, questions about disability status may be asked. The assessment tool that I mentioned called the VI-SPDAT is a relatively comprehensive tool which asks a lot of questions, and it's meant to assess that person's barriers to housing and how vulnerable they are to homelessness. And so many of the questions that are asked as part of that process are very sensitive and personal in nature. And therefore, as a DV service provider who is participating in a continuum of care, you may be the best person to administer that assessment with your clients because you have that ongoing relationship with the client, and you might be the person with whom the client is the most comfortable answering those questions. In the Balance of State, DV service providers can be trained to use the VI-SPDAT and onboard folks, their clients, into the coordinated entry process and place them on a prioritization list. And there actually is a particular or special prioritization list for folks who don't want a lot of information shared, and so DV service providers can put clients anonymously onto a prioritization list for these services with only sharing minimal and anonymous personal information. However, it's important just to note here that placement of even this limited personal information still requires the client's informed and written consent. When clients are chosen or their spot is up for receipt of these services through a COC agency, they'll be asked to consent to the entry of other personal identifying information into a database that can be accessed by a variety of agencies and individuals who are part of the homelessness system. And so survivors in particular should be aware of how that information can be accessed and talk with the agency about what information they don't want entered. In theory, clients should not be forced to give consent to the entry of that kind of personal information into the database as a condition of receiving services. But in practice, that may be a challenge. And so if that is an issue you're experiencing, I encourage you to get in touch with us so we can help you advocate in those situations. Okay.
Okay, so we're going to talk now about public housing. And the public housing system is overseen by Office of Housing and Urban Development, HUD. And typically a public housing authority is in charge of, they own the property, they manage the property, maintain it. They're in charge of selecting and evicting tenants, establishing local rules. They are required by HUD to have certain rules, but they do have a lot of discretion. And they also create the lease document that tenants have to sign. So applying for public housing, a client could apply where she lives, where she works, or where she wants to live. So a client is not limited to applying to the Public Housing Authority where she currently resides. And so it's worth looking into in your area the different public housing authorities, because the wait list for different properties, different housing authorities might differ, and in some cases might differ greatly. I've included the link where you can find your local public housing authority. This would also be an opportunity if you wanted to use that HUD app. Then you would have access to the different public housing authorities in your area. With public housing, there is a grievance procedure available, and that is outlined in a document called the ACOP, which we'll get into on the next slide. Tenant income is recertified and verified annually. And in general, a family is eligible if their income is 80% of the area median income or less. People who are immigrants can qualify for public housing in certain situations, and if you have specific questions about whether or not a family that includes an immigrant qualifies, please feel free to reach out to me. The waiting list for public housing is often closed depending on the public housing authority and the demand in your area. So if you do get on a waiting list, it's really important to update your address. I had a lot of clients when I was doing this work in Ohio. They were on the waiting list, but then they didn't update their address when they moved, and so they were bumped off the list when their address was not valid. So this document that I referred to on the previous slide is called the Admissions and Continued Occupancy Policy, or ACOP for short. And each housing authority creates their own ACOP. Some of them are online. I found the City of Milwaukee's online. And this is something that is a really good idea for you to request from your housing authority. So if it's not on their website, give them a call and request that they send you a copy of the ACOP. Because it's basically like the Bible of public housing. It includes all of the policies and procedures. It includes information about the grievance procedure, how do you request one, what are the deadlines and timelines for appeals. It's important to note too that the deadlines and timelines for appeals are often very short in public housing, and so it's important to know those so that clients are advised to appeal right away so they don't miss out on that important protection. An ACOP includes information about language access. How do people with limited English proficiency access the public housing? Are things translated? Do they have access to interpreters? It includes the Public Housing Authority's outreach plan, their eligibility and application policies, if they give preference to certain categories, for example, to survivors, to the elderly, to families, to people with disabilities. It includes information about how the rental amount is calculated, this recertification process, transfer policies, and pet policies. The ACOP is a really good opportunity to do advocacy, so request that ACOP from your area and then take a look at it and see how does it treat survivors, how does it treat your clients. The plans are revised periodically, so find out when yours is going to be revised and how they take recommendations into account. So would that be serving on a committee? Would that be requesting to see a draft copy of the new ACOP before it comes out and submitting comments on that? And some things to look at are how your housing authority's ACOP addresses the needs of people with limited English proficiency, survivors, the elderly, people who are coming out of prison, people who are formerly incarcerated, children, immigrants, and what does it look like? How would it treat your clients, and where are some gaps where you'd like to see the ACOP changed? Another thing to look at and to request from your housing authority is a copy of the lease. What does it look like? Is it easily understood by people with low literacy levels? Is it available in other languages? All things to look at and then provide feedback to your housing authority about. So as I said earlier, with public housing, there are some mandates from HUD, but the public housing authorities do have discretion. So there are certain types of criminal activity if an applicant has a conviction for that they have to be rejected. But there are other types of criminal convictions where the housing authority has discretion about whether or not they can accept an application from someone. So mandate from HUD is that applicants have to be notified of the reason for rejection and the right to an informal hearing. And that's a type of situation where if your application is rejected, oftentimes the deadline for requesting that informal hearing is very tight. So sometimes it's even a week. So definitely talk to your clients about appealing right away if they receive a rejection and they think it was in error. Many public housing authorities do consider prior rent paying and eviction history, and so that's something to keep in mind with clients is that if they do have an eviction on their record, that can affect their ability to apply for public housing. And that's something also to work with your public housing authority about. Do they consider eviction history for the past 5 years, for the past 10 years, for the past 7 years, and what would be most favorable for your clients? The public housing authorities do have the discretion to bifurcate a lease and only evict an abuser. So if your client and or spouse or partner are on the same public housing lease and it's an incident of domestic violence, the public housing authority does have the ability to just evict the abuser and leave the survivor on the lease. And that's something also to address with your public housing authority. Do they take that option? Maybe they're not aware of it, talking to them about how that impacts survivors and safety. So in public housing, evictions are only supposed to happen for serious or repeated lease violations or for good cause. And as we talked about, the tenant is entitled to a grievance hearing before the eviction with a couple of exceptions that are on the slide there. Even prior to the grievance hearing, if the tenant qualifies for a grievance hearing, the authority does an informal review and they can engage in a settlement at that point. So for the grievance hearing, things to keep in mind: review and copy documents before the hearing. So that would be like going to the public housing authority's, the manager's office, and asking to see any relevant documents and getting copies of those and understanding what those say before the hearing. Can be represented. You do have the opportunity to confront and cross-examine any witnesses and bring your own witnesses. You are entitled to a written decision based on the facts presented. And it is supposed to be before an impartial hearing officer, and you do have the right to appeal that decision if it's unfavorable. Okay, so now we're going to talk a little bit about voucher programs. Section 8 is the most well-known type of voucher, and we'll talk a little bit about other types of vouchers at the end of this section. So HUD provides funds to public housing agencies who administer the programs locally. And once a tenant qualifies and receives their voucher, it's up to the tenant to find a private landlord, and then the private landlord and the housing authority enter into what's called a housing assistance payment contract. And the housing authority actually pays the landlord directly. And if the amount of rent is over the amount that the tenant receives on the voucher, then it's the tenant's responsibility to pay the remainder of the rent directly to the landlord. So the landlord then signs a lease with the tenant. And I included a kind of a screenshot of the Housing Choice Voucher Program Administrative Plan for the City of Madison. That's something, too, I noticed when I was looking around at different housing authorities' websites. Some of these plans are online, but some of them are not. But just because it's not online doesn't mean that your housing authority doesn't have it. It's just they haven't put it online. So definitely request copies of that if your housing authority does not have it online. So the application process, you can apply by filling out an application with your housing authority, and I listed a link there. This is also another opportunity where you could use that app to find information about applications. There's usually a waiting list or a lottery system, and just as an example, earlier this year, Milwaukee County's program started accepting applications for the voucher program for the first time in 15 years. So this is something where if you hear that the voucher program is accepting applications in your area, that's definitely something to jump on and to really encourage clients to do, because the waiting periods are sometimes very long and the application periods don't come around very often depending on your area. Again, this is something where it's really important to update your contact information. So if you have a client who's on the waiting list, definitely encouraging that client to update the housing authority with new address, new phone number information to stay on that waiting list. So for evictions with the voucher program, the landlord uses the regular eviction procedure that they would use for any tenant to evict a voucher tenant. Another issue that comes up with voucher cases are voucher terminations. So a public housing authority is able to use an administrative procedure, an informal hearing, to terminate someone's voucher for various reasons. They do have to give notice of the reason and give an informal hearing, opportunity for an informal hearing to the tenant, and they do have to have good cause to terminate the voucher. Some of the other voucher programs which we are not going to get into the details about are the HUD Veterans Affairs and Supportive Housing Voucher, often referred to as HUD VASH. There are home ownership vouchers, project-based vouchers, and I did want to let everybody know that there is a HUD VASH conference call coming up. It's called Engaging and Partnering with the Business Community to End Veteran Homelessness, and it's on October 20th, 2016 at 1 p.m. our time. And to RSVP, you would need to email or go to www.att-rsvp.com. The confirmation is 404322. And there's also a replay of a teleconference about tight rental markets. And that is, the phone number is 800-475-6701. The code is 402942. And that might be a good teleconference to listen into, even if you're not interested specifically in the HUD VASH voucher, but if you have a tight housing market. So there are housing markets where even if a tenant has a voucher, it's difficult for them to find a landlord who will accept it. So if you're in that situation, I encourage you to call into that replay of the teleconference for ideas about how to work with that.
Thanks, Megan. And then finally, we'll talk about protections specifically for victims of domestic violence, sexual assault, stalking, and dating violence that are part of the Violence Against Women Act and that apply for survivors who are involved in public housing programs. And before we do that, it's, I think, worthwhile to point out that many of the protections that we're talking about that specifically apply to federal public housing programs have parallel provisions in state law that apply to rental housing generally in the state of Wisconsin. So for example, we'll talk about an anti-discrimination provision in federal law. We also have an anti-discrimination in state law that says landlords may not discriminate against victims of domestic violence, sexual assault, or stalking in any rental housing situation in the state of Wisconsin. So just something to keep in mind. If you're working with a client who's not necessarily involved in public housing, but one of these protections would be helpful, there likely is a related state law that you may be able to take advantage of. So the protections that we'll be talking about in most cases existed prior to the 2013 reauthorization of the Violence Against Women Act. But VAWA 2013 clarified that these protections, of course, apply both to men and women. And it also expanded the types of federal housing assistance to which these protections apply. So not only does it apply to public housing projects, Section 8 vouchers, and project-based Section 8 housing, but it also applies to a variety of federal housing programs which you see listed there, including supportive housing for the elderly, supportive housing for people with disabilities, and the homelessness programs that we discussed earlier. So who is protected under these provisions? As I've mentioned, it's individuals who have been subject to domestic violence, dating violence, stalking, or sexual assault, and includes what the law terms affiliated individuals. So in addition to the actual victim of those violence, immediate family, or individuals who are living in the household who are not perpetrators. And as I alluded to, the VAWA protections say that public housing authorities, landlords, and owners who are participating in federal housing programs shall not deny an applicant housing on the basis of that person's victimization as a victim of domestic violence, dating violence, sexual assault, or stalking. And we hear about this sometimes in subsidized housing or federal housing, and generally in Wisconsin, when landlords will do CCAP checks and maybe see a court record that suggests to them that the person who has applied for housing has been a victim of domestic violence, and they make an assumption that the person who's applying may be a poor tenant as a result. So both state law and federal law for public housing prohibit that type of discrimination. If it's something that you hear about or you know about, it's something that we can help with. In addition to upfront discrimination, the VAWA provisions have eviction protections for survivors. And so public housing authorities or those landlords that are participating in federal housing programs cannot evict a tenant on the basis that he or she has been a survivor of domestic violence, sexual assault, stalking, or dating violence. And remember that this provision is set against that background that Megan was talking about earlier of crime-free lease provisions and one-strike policies that give public housing authorities and landlords a lot of discretion to evict recipients of public housing assistance for crimes committed by their family members, themselves, or guests. And often that discretion applies regardless of whether the person responsible for the crime is the tenant. Generally speaking, criminal activity that occurs in the dwelling, the landlord may have, or the public housing authority may have discretion to evict that entire family. But crimes against a survivor directly relating to the abuse are not grounds for evicting the survivor or the affiliate individuals. And the law clarifies that an incident or threatened domestic violence does not constitute a serious or repeated lease violation or good cause for evicting a survivor or terminating a rental subsidy. There is a very, very limited exception to these protections, and that is that public housing authorities, landlords, and owners can still evict if they can show that, for our purposes, a victim of domestic violence, if they were to remain, is an actual and imminent threat to other tenants or employees at the property. And so that term, actual and imminent threat, is not defined, but it is a very high bar, and it only is met when there is no other action that could be taken that would reduce or eliminate that threat. As alluded to earlier, public housing authorities can terminate a Section 8 voucher to an abuser while preserving assistance to the survivor. This is similar to the lease bifurcation that Megan talked about. And the law states that if a family breakup results from domestic violence, that the public housing authority must ensure that the rental assistance remains with the victim. And again, if Section 8 voucher family moves out in violation of the lease, so they leave early, the public housing authority has grounds to terminate their subsidy, but VAWA provides an exception for survivors who must move and are fleeing for their safety. So with all of these provisions, how a survivor proves that she is a survivor of domestic violence can be an issue. And the law gives public housing authorities a lot of discretion to simply take a tenant at his or her word that they are a survivor of domestic violence. Or they can request some proof, but that request must be in writing, and it must give the tenant at least 14 business days to provide that documentation. HUD actually has a form, which is linked to their Form 50066, which allows the survivor to provide that supporting information. Other options for documentation include police, court, or other government records, or a statement from a third party like a domestic violence service provider stating that the individual is a survivor and that that the service provider is working with the individual. That must be signed both by the survivor and the third party. So in this example, by the domestic violence agency. I think I just want to kind of echo in this regard what Megan talked about, that there are lots of opportunities for advocacy in this area. And so the ACOP that she talked about should include these provisions or regulations and rules that implement these provisions for local public housing authorities. And I think it's important in these situations that you look for opportunities to be proactive, to not assume that public housing authorities know about these protections or are implementing them correctly. It's an opportunity to ask to meet with the public housing authority. VAWA 2013, the actual implementation of it wasn't too long ago, so that can be an opportunity to ask to meet. And you can, in some ways, just politely ask to see some of these policies, particularly around emergency transfers and preserving housing vouchers, so that you can help explain them to your client. And then if there's something about the policy that's lacking or the policy hasn't been developed yet, that's an opportunity to provide input and to kind of move things along. I think that I may have missed this slide. So just kind of cycling back, the emergency transfer provisions of the Violence Against Women Act mandate that federal housing authorities include and adopt policies for emergency transfers. And so those transfer plans must allow survivors to transfer to another available safe unit if they would be at risk by remaining in that unit, if both the survivor actually affirmatively requests that and if the tenant reasonably believes that they would be threatened with imminent harm and further violence if remaining in that dwelling. So that's again another opportunity to look at the ACOP and figure out if your local public housing authorities have adopted this emergency transfer plan, and if they haven't, how you can kind of guide them to do so. So that was all of the material that we wanted to cover today. We have our contact information right there. And again, please feel free to reach out with questions if you need it, if we can help in any way. Colleen, I'll turn it back over to you and ask if there have been any questions while we've been talking.
This concludes our presentation of project-based housing and housing vouchers, webinar that was recorded on October 18th, 2016.